India has a long history of preventive detention. The Preventive Detention Act, passed by Parliament in 1950, expired at the end of 1969. The Maintenance of Internal Security Act, passed in 1971, was repealed in 1978. But Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, 1974, and the National Security Act 1980 remain. Due to increasing in terrorist-related activities, the Union Government passed the Terrorist and Disruptive Activities Prevention Act, popularly known as TADA, TADA, in 1985. The act, which was meant to curb terrorism, has not been renewed after it lapsed in 1995. The previous cases under the act are unaffected. Even states are empowered to enact such laws so as to maintain public order, production, supply and distribution of goods within their frontiers. In this context, the legislative power to enact a preventive detention law is divided between the Union and the states. The exclusive power of the Union is with regard to matters connected with defense, foreign affairs and the security of India. A state has concurrent power with the Union to provide preventive detention legislation in matters connected with security of that state, maintenance of public order, or maintenance of essential supplies and services. As D.D. Basu observes, so long as the concurrent power of the states to legislate for preventive detention with respect to the aforesaid grounds remains, and any of them feels the need for retaining or making state laws for preventive detention, it is practically difficult for the Union Government to impose its wills on such states. Till then, the existence of Article 22 on the Constitution will be beneficial, rather than prejudicial, to the cause of liberty, because the validity of such state laws can be challenged on the ground of contravention of the safeguards laid down in Article 22. In these circumstances, Article 22 continues to be on the Constitution as a necessary evil. The writs. Habeas corpus. The writ of habeas corpus is in the nature of an order calling upon the person who has detained another to produce the latter before the court in order to let the court know on what ground he has been confirmed and to set him free if there is no legal justification for the imprisonment. The term literally means to have a body. It is a powerful safeguard against arbitrary acts not only of private individuals but also of the executive. The writ is available to enforce the fundamental rights, to ensure that a person is not deprived of his liberty, except in accordance with the procedure established by law. The court issues the writ against the authority concerned if the executive arrests someone without the authority of law or in contravention of procedure established by law, or if the law authorizing the detention is ultra vires the statute. In response to the notice issued by the court, the burden is on the respondents to offer proof of the stand taken. When it is shown that the person detained was last seen alive under the surveillance, control and command of the detaining authority. The writ is not issued if either the person arrested or the person against whom the writ is issued is outside the jurisdiction of the court. If the person concerned has been imprisoned by a court of law on a criminal charge, if the person concerned is involved in proceedings for contempt by a court of record or by Parliament. Mandamus. The writ of mandamus, literally meaning we command, commands the person to whom it is addressed to perform some public or quasi-public legal duty in he has refused to perform and the performance of which cannot be enforced by any other legal remedy. The writ of mandamus can be issued by the court to enforce fundamental rights whenever a public officer or a government has committed an act violating a person's fundamental rights. The court can restrain that authority from enforcing such orders or committing such an act. A high court can issue a writ of mandamus to enforce the performance of a statutory duty, to compel a court or judicial tribunal to exercise its jurisdiction when it has refused to exercise it, to direct a public official or government not to enforce any unconstitutional law. The existence of a statutory remedy is no bar to mandamus where the ground on which relief sought is beyond the competence of the statutory tribunal to entertain. The writ is not issued against a private individual or organization unless the state is in collusion with such a party in contravening a constitutional provision or a statute. It is also not granted against the president or a governor for the exercise and performance of the powers and duties of his office. Nor is this writ issued against a legislature, even though it may be about to enact a law offending the fundamental rights. Prohibition. The writ of prohibition is issued by the Supreme Court or a High Court to an inferior court, forbidding the latter to continue proceedings in a case in excess of its jurisdiction or to usurp a jurisdiction with which it is not legally vested. The writ may be issued also in cases where the court or tribunal assumes jurisdiction under a law which itself contravenes some fundamental right guaranteed by the Constitution. The writ is not available against a public officer not vested with judicial or quasi-judicial functions. The Supreme Court can issue the writ only where a fundamental right is affected because of jurisdictional defect in the proceedings. Certiorari. The writ of certiorari is issued to a lower court after a case has been decided by it, quashing the decision or order. The object is to secure that the jurisdiction of an inferior court or tribunals is properly exercised and that it does not usurp the jurisdiction which it does not possess. The writ is applicable only in case of tribunals or officials having legal authority to determine questions affecting rights of subjects and who have acted without jurisdiction or in excess of legal authority vested in them or in contravention of the rules of national justice. A tribunal is considered to have acted without jurisdiction if the court is not properly constituted, where people are not qualified to sit on it, have pronounced judgment, where the decision has been obtained by fraud, collusion, or corruption, or where the subject matter of inquiry is beyond the scope of the tribunal. Even if the court acts within its jurisdiction, where an error of law has been committed, a writ of certiorari can squash the decision. In short, while prohibition is available during the pendency of the proceedings and before the order is made, certiorari can be issued only after the order has been made under similar circumstances. Quo warranto. The writ of quo warranto is a proceeding by which the court inquires into the legality of the claim which a party asserts to a public offence and to remove him from his enjoyment if the claim is not well founded. For the writ of quo warranto to be issued, the office must be public, created by statute or by the Constitution. The office must be a substantive one, and there should have been a contravention of the Constitution or a statute in appointing the person to that office. The writ of quo warranto enables the public to see that a public office is not usurped by an unlawful claimant, but is a discretionary remedy which the court may allow or refuse according to the facts of each case. It may be refused where it may be vexatious, futile in its result, or where there is an alternative means to oust the usurper. An application challenging the validity of an appointment to a public office is maintainable at the instance of any person, regardless of any fundamental or legal right of that person being infringed. Now the next fundamental right, right against exploitation. Article 23 prohibits traffic in human beings, begar, an indigenous system under which landlords at times compelled their tenants to give free service, and other similar forms of forced labor, and violation of the provision is an offence punishable by law. What is prohibited is the act of compelling a person to offer free service where he or she is entitled either not to work or receive payment for such work. The state is allowed to impose compulsory service for public purposes, provided it does not discriminate on grounds only of religion, race, caste, or class, or any of them. Nor does the clause prohibit forced labor as punishment for a criminal offence. Article 24 prohibits the employment of children below 14 years of age in factories, mines, and hazardous occupations. The prohibition is absolute and admits no exception. 4. Right to freedom of religion. India is a secular state. India has no state religion, nor will it confer any special patronage on any particular religion. Article 25 avers that, subject to public order, morality and health, all persons enjoy freedom of conscience and have the right to entertain any religious belief and to propagate it. However, the state can regulate or restrict the economic, financial, political, or other secular activities associated with religious practices. It can also take measures for social reform and throw open Hindu religious institutions of a public character to all classes of Hindus. Also, this right does not imply permission to convert others forcibly, fraudulently, and by offering inducement or allurement. Article 26 gives every religious group or denomination the right to establish and maintain institutions for religious and charitable purposes, manage its own affairs in matters of religion, own and acquire movable and immovable property, and administer such property in accordance with the law. This guarantee is available not only to the citizens of India, but to all persons, including aliens. Article 27 avers that no citizen will be compelled by the state to pay any taxes for the promotion or maintenance of any particular religion or religious institution. Article 28 stipulates that no religious instruction is to be imparted in a state-funded educational institution. No person can be compelled to receive religious instruction imparted in an institution recognized by the state or receiving aid out of state funds without the consent of the person or his guardian if the person is a minor. The issue of secular. The term secular has confused political observers and laypersons alike, and interested parties have often taken undue advantage of the ambivalence. However, pronouncements of the Supreme Court have made some aspects clear. To quote Dr. D.D. Basu, Secularism in India does not mean that the state should be hostile to religion, but that it should be neutral as between the different religions. Every individual has the freedom to profess and practice his own religion, and it cannot be contended that if a person is a devout Hindu or a devout Muslim, he ceases to be secular. The use of the vague word secular in the preamble would not override the enacted provisions in Articles 25 to 30 or Article 351, so that the preference of Sanskrit in the academic syllabus as an elective subject, while not conceding this status to Arabic or Persian or the like, would not militate against the basic tenets of secularism. The neutrality of the state would be violated if religion is used for political purposes and advocated by political parties for their political ends. An appeal to the electorate on grounds of religion offends secular democracy. Politics and religion cannot be mixed. If a state government does this, it will be a fit case for application of Article 356 of the Constitution against it. It is in this sense that secularism is to be regarded as a basic feature of the Constitution. The issue of conversion. In recent years, the issue of conversion, especially into the Christian belief, has become controversial and has even taken an ugly turn at times. In this context, the Supreme Court has reached some clear decisions, especially in the Stanislaus case of 1977, which was brought by a Christian priest seeking to invalidate an act of Madhya Pradesh. The act made it a penal offence to convert or to attempt to convert a person by means of fraud, force, or allurement. Orissa had earlier framed a similar act with the word inducement in place of allurement, and the constitutionality of that act had also been challenged by some members of the Christian community. The Supreme Court considered both acts and upheld their constitutional validity, rejecting all the contentions of the Christian community. The court laid down some propositions that are binding on all courts of India. 1. The right to propagate means the right to spread the tenets of one's religion, say by preaching, but it would not include the right to convert another, because each person enjoys the same freedom of conscience guaranteed by that very provision, Article 25, Clause 1, on which the Christians based their case. 2. A person has the right to choose and hold any faith he likes and not be converted into another religion by force, fraud, allurement, or inducement. Naturally, he may voluntarily choose to adopt another religion. 3. The guarantee of freedom of religion under Article 25, Clause 1 is also subject to public order, morality, or health. It follows that the state can intervene if the activity of conversion offended against public order, morality, and health. Such intervention would be valid even if a particular religion had the right to propagate through the means of conversion. 4. If the right to convert is accepted as valid, that right would belong to every religion. With every religion carrying on a campaign to convert persons to his own faith, by any means, there was bound to be a breakdown of public order. In such circumstances, the state would be within its constitutional authority to maintain public order by penalizing such attempts to convert by force, fraud, or inducement. The Madhya Pradesh and Orissa Acts had only done what was constitutional. The Arunachal Pradesh legislature also passed a bill modelled on the Madhya Pradesh and Orissa Acts. There have been agitations by Christians who have politicized the issue, saying that the measures were directed against their community in particular. This is not quite true. The disputed bills would operate against any religious community if it resorts to any of the unlawful means mentioned. If international charters were to be quoted in support of conversion, one cannot suppress what the International Covenant on Civil and Political Rights 1966 says. No one shall be subject to coercion which would impair his freedom to have or to adopt a religion or belief of his choice. The disputed Indian bills, in banning the use of force as a means of conversion, are well in accord with the International Charter. The use of fraud in conversion, again, impairs the freedom of choice of an individual. Even the use of allurement or inducement does impair the individual's freedom of choice, though these terms are not mentioned in the International Covenant. However, the validity of these terms in this country would depend on the interpretation of the words in the context of public order and morality as dictated by the Indian Constitution. We will continue with the topic of fundamental rights in the next section.